told that I should ask you to ask questions rather than make speeches, if you can.
Thank you, Professor Tribe. My question involves the use of intentional torts by federal agents in the investigation of certain people like William Jewell and more recently Stephen Hatfield. Do you know of any legal laws that can be used as Stephen Hatfield used the Privacy Act to put a stop to this? And is there any point at which you believe intentional torts reach the point of a civil rights violation? Thank you.
The question, without going into the particular individuals and rephrasing it to make it a very, very general relevance, is whether there are any protections against the deliberate infliction of harm, tort, by a federal agent intended basically to pressure people into doing things they may not want to do or punish them. I actually had a case in the Supreme Court dealing with that very question, the most recent one I argued, and I to tell you just a little bit about it so you get the flavor. There's this rancher in Wyoming who had some land that the government very much wanted. They wanted an easement over his ranch. And he said, I'm happy to sell it to you. And they said, sell it? We want it. Hand it over. And he said, thanks, but no thanks. I guess we've heard that phrase in another context. This wasn't, they didn't want a bridge to nowhere over his land, they just wanted a bridge. And they undertook then to engage in what I suppose you would call intentional torts. They harassed the people who came to his dude ranch. They drove him out of business. And there was no federal statute, and there often is no federal statute, that allows you automatically to sue federal officials who intentionally inflict harm. He argued that this violated the just compensation clause of the Constitution, the Fifth Amendment, which says that the government can't take private property for public use without just compensation. The government's answer was, we didn't take your property. We tried to make you give it to us. You resisted, and too bad for you that you went out of business. And I agreed to take this case pro bono because I thought this was quite a terrible abuse. And I argued it all the way to the Supreme Court, and by a divided vote I lost. The Supreme Court said, yes, it's true that what happened to him was pretty terrible. It's what some people might call death by 1,000 cuts. Until Congress passes a law providing protection, it's not an appropriate thing for us to do to provide a remedy. Needless to say, I thought that it was an appropriate thing for the court to do in order, under that kind of geodesic dome, to provide meaningful protection for the rights involved. And the court had held in an earlier case, when 6 FBI agents trashed someone's home, and there was no statute authorizing the victim to sue them for damages, held that that suit would be appropriately brought. The bottom line is that, unfortunately, in my view at least unfortunately, some on the left of the court and some on the right are not very enthusiastic about lawsuits generally, especially lawsuits against government officials. It wasn't only a justice like Scalia who ruled that there should be no ability to sue the guys who drove the rancher out of business. It was also my friend and former colleague Steve Breyer, who isn't very hot on lawsuits. Thinks that litigation is not a great idea. Now you might wonder, how can the question of whether a justice likes lawsuits have anything to do with how a decision like this should come out? Well, the answer is that most of the questions that have clear-cut answers in settled law don't make it all the way to the Supreme Court. The questions that get there are questions on which the person's basic views of the world, their basic orientation. Is it appropriate for judges to help the victims of this kind of violation get redress unless Congress says no? Or should we require that the behemoth of Congress say yes before any remedy is available? That basic orientation toward the world is what makes the difference between the kinds of people that, let's say, John McCain might appoint to the Supreme Court, and people that Barack Obama says he'd like to appoint. He says he wants to appoint people whose views of the world provide a lens through which they view the Constitution. It makes it a little more user-friendly in the way he thinks it should be. Question over here.
Yeah, The 73 War Powers Act has kind of fallen into a state of limbo over the last couple of decades, especially since Clinton continued to bomb the Balkans for more than 60 days. I think you once expressed an opinion that at least one aspect of that resolution relating to congressional veto or presidential power might be unconstitutional. But do you think there's a sound constitutional basis for much stricter War Powers resolution with some real teeth in it?
Yes, the War Powers Resolution of 1973 that grew out of the events in Vietnam was intended to put various kinds of constraints on the ability of the president as commander-in-chief, not simply to direct the tactics of a military adventure, but to undertake a war without congressional authorization. Part of that act, I think everyone now agrees, violated a basic principle of the structure of government. It was the part that basically said that Congress, by mere concurrent resolution, without passing a law, can simply agree by a majority vote in the House and the Senate to end an otherwise lawful military action. Well, the Supreme Court has made clear that it takes a law enacted by Congress to change the rules under which the executive operates. Under a decision called Immigration and Naturalization Services versus Chadha. So that part of the law that attempted to let Congress, without passing an actual law presented to the president for signature or veto, alter the legal landscape, was unconstitutional. The part of the law that has not been tested and that every president has questioned as constitutional is the part that basically says Congress can put a leash on the president. It can tell the president that unless within a certain number of days of entering military personnel into a hostile situation, the president comes back to Congress, that occupation must end. In other words, it puts a leash on the president that says that the president has a kind of general authority to engage in military activities, but only with a fixed time horizon. And after that time horizon, he's got to stop unless Congress gives him a green light. A lot of people think that that is too tight a leash on the commander-in-chief power. Presidents of both parties have taken that view, and I suspect the Supreme Court would take that view as well. That doesn't mean that the president has unfettered power simply to wage an aggressive war. It does mean that the Supreme Court is probably not going to stop him. The only thing that might stop the president is a defunding of the war or the bringing of impeachment charges against the president. But it is probably not proper reading of the Constitution to say that the president needs a declaration of war in order to wage war. It's much more complicated than that. It's pretty clear that the Constitution's whole design contemplates that the president can sometimes wage war for purposes that are more limited without getting a war declaration. And what makes the thing even more complicated is that without a declaration of war, the president can often get an authorization by Congress. The Gulf of Tonkin authorization in Vietnam, or the authorization that Congress gave this president to go into Iraq. The Supreme Court is unlikely to say, well, that was an authorization, but you need a declaration. Probably going to say that as long as Congress has given a green light to the president to wage war, you're not even close to the edge of the constitutional precipice. The question of whether the president can be impeached and removed from office for lying in order to get an authorization is itself a difficult one, but as I'm sure you all know, Nancy Pelosi and the Democratic leadership, believing that it would make them sort of bog them down in a retrospective attempt to impose accountability rather than some forward-looking activity solving the nation's economic crises, have taken the whole impeachment question off the table, which is, I guess, where it still remains.